Good afternoon, everyone, and welcome to the Committee for Justice's virtual panel discussion, Asian Americans Challenges to Affirmative Action and Admissions Reaches Supreme Court. I'm your host, Ashley Baker, and I'm the Director of Public Policy at the Committee for Justice. And now I'm going to introduce the panelists in the order in which they will be speaking. First, we have Kurt Levy. Kurt Levy is president of the Committee for Justice. He has expertise in constitutional law, civil rights, the federal judiciary, and intellectual property. After graduating Harvard Law School with honors and clerking for the U.S. Court of Appeals for the Sixth Circuit, Mr. Levy served as Director of Legal and Public Affairs at the Center for Individual Rights, where he worked on Supreme Court cases challenging race-based admissions and Congress's Commerce Clause authority. After CIR, he headed the Title IX policy group at the Department of Education's Office for Civil Rights. Before attending law school, Mr. Levy earned undergraduate and graduate degrees in computer science from Brown University. Subsequently, he worked as a scientist at HNC Software in San Diego, where he designed and built numerous AI systems, published peer-reviewed articles about machine learning, and invented and patented pioneering technology for adding explanatory capabilities to AI models. Edward Blum is president of the Project on Fair Representation, where he has provided counsel in 5 lawsuits argued before the United States Supreme Court, including Fisher versus University of Texas 1 and 2, a challenge to a race-based admissions policy, and Shelby County v. Holder, a challenge to the constitutionality of Section 5 of the Voting Rights Act. Blum is also the founder and president of Students for Fair Admission, which has over 24,000 members. Its mission is to end the use of racial and ethnic preferences in college admissions. Currently, SFFA is challenging admissions policies at Harvard, the University of North Carolina, the University of Texas, and Yale. The Harvard lawsuit is currently being appealed to the United States Supreme Court. Blum is author of a book, law review articles, essays, and dozens of op-eds in publications such as the Wall Street Journal, Washington Post, and the LA Times. Since 2005, he has been a visiting scholar at the American Enterprise Institute. And last but not least, we have Chris Kieser. Chris Kieser is an attorney at the Pacific Legal Foundation, where he practices in the property rights and equality before the law groups. He represents coalitions of Asian American parents challenging discriminatory policies in selective K-12 schools in New York City, Montgomery County, Maryland, and Fairfax County, Virginia. He also represents a parents organization in Connecticut challenging a quota that prevents many Black and Hispanic students from enrolling at the state's magnet schools. Chris has published law review articles in the William & Mary Environmental Law Review and at the Federal Society Review. His op-eds have appeared in National Review and other national publications. Chris clerked for the Honorable Daniel Mannion of the U.S. Court of Appeals for the 7th Circuit and the Honorable Thomas Schroeder of the U.S. District Court in North Carolina. He graduated magna cum laude from the Notre Dame Law School in 2013, where he was an articles editor at the Notre Dame Law Review. So the brief presentations by our panelists are going to be followed by a discussion, after which we will open up the floor for audience Q&A. The way that I do Q&A is kind of a housekeeping note. If you have a question, you send it in through Q&A if you see at the bottom of your screen, and you can go ahead and send me those questions at any point throughout the discussion, and I will work those in during the Q&A session at the end of the panel. And with that, Kurt, the floor is yours.
Thank you very much, Ashley. Unlike Ed and Chris, who are battling race-based admissions in the courts today, my participation in the battle was years ago, just after I got out of law school. And I guess I should note that I like the term race-based admissions. It's sort of a compromise between the feel-good term affirmative action and the politically incorrect term racial preferences. Of course, they are racial preferences, but I use the compromise term. So my battle dates back to my days at the Center for Individual Rights. And just to provide some sort of history of the battles to the audience, tell you I worked on the Hopwood case against the University of Texas, the Smith case against the University of Washington, Gratz and Grutter cases against the University of Michigan. Those reached the Supreme Court. And we did have for a short time after we won in the 5th Circuit in Hopwood, race-based admissions was illegal in the 5th Circuit, Texas, Louisiana, and Mississippi. But then our University of Michigan suits reached the Supreme Court. We won the college case and lost the law school case against University of Michigan. But most importantly, and I guess unfortunately, the court made clear that the educational benefits of diversity are a compelling interest that can justify racial discrimination. the so-called diversity rationale. Now, in Gratz, the college case that we won, the court stressed that race must be a modest factor and one of many used to achieve intellectual diversity. That's basically the narrow tailoring standard the court applied. The court also said that race-based admissions should sunset in 25 years, something that now that we're getting close to that, everyone ignores. To understand the history of these legal challenges, you really need to understand the diversity rationale under which these policies have been upheld. So let me start there. The Constitution and admissions Title VI prohibit racial discrimination, and courts apply strict scrutiny to any racial discrimination. It can be overcome only by a compelling government interest. And even though sort of, in the public debate, schools say we're not doing anything wrong, they do admit that they're discriminating. And they just say it's justified because of the educational benefits of diversity being a compelling interest. And, the court sort of agreed with that in Bakke in 1978, and then made it official in the cases in 2003. Now, before Bakke and there were only two such compelling interests that could justify racial discrimination. One was providing a remedy for individuals who were discriminated against, not a remedy for, structural racism, as people like to say today, but a remedy for individuals who were discriminated against, and national security. That was primarily in the now discredited Korematsu case about Japanese internment. So really very little can justify racial discrimination. For example, we can't give young Arab men more scrutiny at airports, even though it might save a lot of lives, because that's how high the barrier is. So, how the heck do the educational benefits of diversity, which research shows are either slight or non-existent, qualify as this so compelling interest? Well, I guess there's a few answers. I mean, the legal answer is the court says so that makes it so. The political answer is that it's easier to sell the idea of excluding Asians and whites if you say you're not doing it for the other racial groups, you're doing it for all students. The historical answer, really dates back to Alan Bakke's suit against a racial quota at the University of California Davis Medical School. It just so happens that in the decision in the Supreme Court on that, 4 justices thought it was illegal, 4 justices said it was justified to remedy basically structural racism. And then 1 justice, Lewis Powell, tried to split the baby, saying that Bakke had to be admitted, but that policies that other schools used, that used race not in a quota, but as one factor to achieve intellectual diversity, that passed constitutional muster. Powell's opinion was viewed, at least by supporters, as the governing opinion, and thus the diversity rationale was born. It still took a little while for it to creep into our language. Someone once did a study and showed that it was not until the 80s that diversity sort of became a word that everyone was using. But at least it was a rationale, and then it was officially adopted by the court in Grutter in 2003. And 18 years later, the diversity rationale still governs. Ed and Chris can tell you whether they think it will survive this current round of legal challenges. But let me, as the last thing, touch on why I think the diversity rationale is so questionable. I remember around the time of the Michigan cases, I was on a panel about it at Harvard, and I was the only sort of critic of race-based admissions. And yet, of the other 9, only one of them thought that the educational benefits of diversity was the real reason for why we have race-based admissions. So for starters, it's a disingenuous rationale. The truth is they want diversity for diversity's sake, not because it helps white kids get a better education. But they can't say that because the Supreme Court has said that racial balancing for its own sake, essentially quotas are unconstitutional. I like to do a little thought experiment. If we could prove with absolute certainty that students can get as good an education on a non-diverse campus, do you really think the support for race-based admissions would go down at all? Of course it wouldn't. It's really about politics, not about educational benefits. The University of Michigan, for example, gave preferences to Mexican Americans, but not Mexicans. Now, that's not because people living in Mexico would add less to diversity. It's because Mexican Americans are an influential, political group in this country, and people living in Mexico are not. And who could add more to the diversity of viewpoints than, Black conservative students? But, good luck. Good luck being recruited by the top colleges. It's also disingenuous because of the idea that, race is just used as a small factor as required by Grutter. That's just belied by all the statistical analyses. In the Grutter case against Law School, our analyses showed that being Black actually was equivalent to more than a full letter grade preference. Another problem with diversity rationale is it really allows no limits on the scope or duration. There's no duration limit because there's always going to be, some racial, ethnic, or religious group that's small in numbers or percentage. And there's no scope limit because this court has said that schools can define the critical mass, i.e. how many of each minority group you need to get these educational benefits. Finally, at the end of the day, this doesn't even increase the racial diversity at the nation's school. It just sort of robs, the Ivy League take school minority students that would have gone to a slightly lesser school, and then those schools take minority students that would have gone to a slightly lesser school than that. And at the end of the day, they're just robbing from each other, and the overall diversity is not increased. Poor Black kids in the inner city are still not going to college, and I better stop there.
Thank you, Kurt. Now, Ed, the floor is yours.
Thanks, Kurt. I want to avoid sounding like James Michener and beginning my short talk by taking us into the sort of the bones buried in the earth. But Kurt started it, so I'm going to backtrack a little bit and take up where Kurt started. And that is with a very important case that came out of the state of Texas, Hopwood versus Texas. And thank you for your service in that, Kurt. We got a great ruling out of the Fifth Circuit, and the University of Texas was compelled, along with all the other public schools in the Fifth Circuit, to stop using race. Well, now comes Grutter, in which basically that ruling was set aside. The day that Grutter came out, the president of the University of Texas announced publicly that very soon the University of Texas will start using race once again. Now, what happened between the Hopwood decision and now the Grutter decision was that the legislature of the state of Texas enacted something called the Top 10% Plan, now forbidden to use race and ethnicity as an admissions factor. The entire state of Texas, if you were a graduating high school student in the top 10% of your class, you were automatically admitted to any university in the state, including the University of Texas at Austin. So what happened with that? Well, within 2 years, the diversity, and by diversity, we're talking about skin color diversity, the skin color and ethnic diversity at the University of Texas exceeded the diversity that was in place prior to Hopwood. So now we have a race-neutral alternative that has created the diversity, a greater amount of diversity than was in effect with affirmative action, race-based affirmative action. Now, the University of Texas reinstitutes the use of race in admissions. Abigail Fisher in 2008 was denied her admittance to the University of Texas. She was in the 11th percentile of her graduating class. And one of my organizations, the Project on Fair Representation, provided counsel to Abby in her lawsuit against the University of Texas. That lawsuit argued that the University of Texas's reintroduction of race violated the narrow allowance that was set down in Grutter and Gratz. Abby never alleged that Grutter and Gratz were decided incorrectly. So now we have a full-blown lawsuit against the University of Texas. It made it to the US Supreme Court in 2012. It was argued October of 2012. And then a month later, something kind of interesting happened. A guy by the name of Ron Unz, who was a very successful Silicon Valley high-tech entrepreneur, wrote an article. I think the article was entitled "The Myth of Meritocracy," and it was published in a conservative, serious conservative quarterly or monthly journal. That article caused quite a stir within higher education, and David Brooks of the New York Times wrote about it, and my phone started to ring, and emails started coming in about that article, and that article specifically talked about the Asian penalties, the quotas on Asians at Harvard and Yale and all the other Ivy League schools. And Ron Unz had done some investigation. I think at one time, Harvard and Yale made a lot of these data points public. So what he pointed out was that basically, even though the number of applicants to Harvard had gone up significantly over a 20-year period, the percentage of Asians being admitted. Let me restate that. I may have screwed that up. The raw number of Asians applying to Harvard and Yale and Princeton had gone up significantly over a 20-year period, but the percentage of Asians admitted stayed the same. Now, that was revelatory. And that is what I think generated a lot of phone calls to me, a lot of phone calls, I think, to other public interest legal groups, lawyers, and what have you. And it was about then that the idea that Asians were being discriminated against specifically by Harvard and Yale and Princeton, that became kind of a sitting target for me and the lawyers that I were working with. Now comes the summer of 2013. Abby Fisher's opinion is rendered. It is a 7-1 opinion with Justice Ginsburg dissenting, in which Justice Kennedy raised the legal bar for the use of race. The level of scrutiny became much higher, and that case, our Abby versus Texas, was remanded back to the Fifth Circuit. This is the summer of 2013. It was at that kind of new legal hurdle that allowed us to form Students for Fair Admissions, to then target Harvard. And as now we all know, Harvard was sued November of 2014, arguing that race was a predominant factor in Harvard's admissions factors. They were balancing by race, and they were purposefully discriminating against Asian Americans based upon their kind of personality traits. We had a bench trial in 2018. A year later, we lost at the district court. A few months after that, we lost at the First Circuit. We are now on appeal at the Supreme Court. This case goes to conference on June the 10th. Let me read to you the two questions that have been presented. Question number one, should this court overrule Grutter versus Bollinger and hold that institutions of higher education cannot use race as a factor in admissions? And second question, Title VI of the Civil Rights Act bans race-based admissions that, if done by a public university, would violate the Equal Protection Clause. Is Harvard violating Title VI by penalizing Asian American applicants, engaging in racial balancing, overemphasizing race, and rejecting workable race-neutral alternatives? It has been my experience that cert petitions come in one size and one size only, and that is slim. It is my hope and the hope of, I think, the vast majority of Americans in this country that the Supreme Court grants cert in this case and addresses both questions so that the use of race and ethnicity is now, will forever be outlawed by new jurisprudence. Chris?
Great, thanks, Ed. So I'm gonna go in a slightly different direction because whereas Ed and Students for Fair Admissions is concentrating on the college level and dealing with race-based admissions at that level, Pacific Legal Foundation in my cases have been focused on sort of a new trend of racial discrimination at selective K through 12 schools. That includes magnet schools at the high school level and even at the middle school level. And they don't take the form of explicit racial preferences like you might find in the higher education context. So the legal issues presented are actually slightly different in the sense that you have to prove discriminatory intent before you can even get to the issues of whether the diversity rationale should be a compelling interest. So I want to talk about a few cases that we are currently litigating and how those might play into the broader movement to eliminate racial preferences in education. The first one is a case that we recently filed called Coalition for TJ versus Fairfax County School Board, and that involves the admissions process at Thomas Jefferson High School in Fairfax County, which is U.S. News and World Report says is the best public high school in America right now. It's it was formerly an exam school that took the highest scoring students on a long-standing admissions exam from Fairfax County and surrounding areas, about a class of about 500 students, and it was highly competitive, focused on STEM, and it was also 73% Asian American in the last school year before the changes. Well, in 2020, the Virginia General Assembly passed a statute that basically said to all so-called governor schools in Virginia that they had to start implementing, or at least discussing, diversity plans. And most people thought, well, this is aimed at Thomas Jefferson because year after year, Thomas Jefferson is known to have a heavily Asian American student body, and a lot of people think that they shouldn't have one. So within a few months, the school board in Fairfax County set about to devise a plan to entirely overhaul the admissions process at Thomas Jefferson. They voted to get rid of the examination requirement, and then 2 months later, they instituted a new process which limited the number of seats available from each constituent middle school in Fairfax County to the top 1.5% of those students, not based on any exam score or objective criteria, but based on a holistic evaluation of 13 factors, some of which were non-quantifiable, and others were that simply were designed to hurt students coming from middle schools they deemed to be overrepresented which all happen to have more Asian American students than Fairfax County as a whole. And so they implemented this process, and they say, well, it's race neutral because we don't look at the students' race or even their name when we decide their application. It's entirely race, school, or it's not school blind, but it's race and name blind. And so they've defended this on the grounds that it's race neutral. Now we, and a lot of other, the parents group called Coalition for TJ was formed basically because they view this as a covert racial preferences program, and the school district's modeling of the changes bears that out. They expect that the number of Asian students to get in and for the next year at Thomas Jefferson will be about 40% fewer than who have gotten in the past. And that's not by accident. That's how the program was designed. And so we filed a lawsuit alleging that the school board intended to discriminate against Asian American students. And it's clear from the discussion that at the board meetings that race was the number one concern on the minds of the school board members, the superintendent, and the principal of TJ. They were all talking about how the school needs to be reflective of the diversity of Northern Virginia and Fairfax County. Plain language of racial balancing. However, it's facially race neutral. So this is how our cases are different from the higher education cases. And actually, sort of, we intersect with, Ed was talking about the top 10% plan at the University of Texas, and how, in the Fisher case, the justices, at least several of the justices, referred to that as race neutral. And of course, it is on its face race neutral. But these high schools like Thomas Jefferson have figured out how to use race neutral criteria as a proxy for race in such a way that they can essentially approximate the results of a racial quota without using one. And so in our sort of new frontier of these cases over the last few years, we've been trying to prove that the intent to racially balance a school in a facially race neutral way is discriminatory intent, and therefore the court should treat it just as it would treat a explicit race preference case, like a Grutter or a Fisher, and subject it to strict scrutiny. And then the second level of that is the diversity rationale that we've been talking about. That's never been extended explicitly to K through 12 schools, and I think there's a reason for that. And the reason is it's alluded to in the majority opinion in Parents Involved, where the court says, well, that there's unique considerations involved in higher education, and then they allude to sort of academic freedom. But another thing is intellectual diversity. The court doesn't mention this, but is a much more salient concern of an admissions counselor at in higher education than it would be for somebody who's putting together a class for a K through 12 STEM or a STEM magnet school. And the court didn't say this explicitly, but it did say that if you want to use race to have an admissions process at a high school, you can't rely just simply on the Grutter diversity rationale. It has to be something else. And what that something else is entirely unclear. So we have a two-step process of, we have to first prove that the racial, the sort of covert racial balancing, whether it's in the form of geographic quotas, getting rid of the test that's sorted, that's allowed Asian applicants to do so well in the past, geographic quota, or as in our case in New York City, Crystal McAuliffe Intermediate School, PTO versus de Blasio. In that case, they used school-wide disadvantage criteria that the city created to exclude students from certain middle schools from a program designed for low-income kids. even if those kids were themselves low income, they went to a school that the city said was poor, but not poor enough to be low income according to them, then they were excluded from that program that was designed for low income kids. And it turned out that before they implemented the plan, that a majority of, or at least a good portion of the schools who were just below the cutoff that they selected for eligibility were heavily Asian schools that had sent a lot of students to the New York City specialized high schools, which are 8 elite test-in public schools in New York City. So that program was changed in order to, the whole point of it was so that to change the demographics of the students who would be eligible to participate in that program. And that's sort of like, it's a combination of a geographic quota and a quota that they use at a school level that is not about individual characteristics, but about school characteristics. And it's able to use sort of demographic trends to exclude Asian Americans from those seats. Whether those programs work is another story. Sometimes the data doesn't really show up the way they expect, but that is the trend going on in these K through 12 cases where these school boards, and it's happening in other cities too. Boston, there was just a case that a group of parents that we didn't represent, but a group of parents sued Boston schools, and they've lost in the First Circuit on an emergency appeal. That was essentially a zip code based quota that was designed to reduce the number of Asian kids at Boston Latin, which is Boston's elite test-in school. These programs all take sort of the same form, but what makes them different is that they are facially race neutral and designed in such a way to achieve the same results as a race-based plan. So there are 2 questions. First, is that enough to prove discriminatory intent? And second, if you can prove discriminatory intent, can we limit the diversity rationale, even if we don't get Grutter overruled, like the Harvard case is trying to do? Can we limit the diversity rationale to higher education so that K through 12 school boards can't engage in this sort of racial balancing? So our front is a little more complex, and in the long run may sort of conflict with, we're going to have to eventually deal with whether top 10% plans or straight geographic quotas enacted plainly for a racial purpose are constitutional or are they not? But that's a question that can be answered down the road without, upending what already happened.
Thank you, Chris. Just to start off the discussion, I'll ask a question that should apply to kind of all the cases here across the board. So, and one noticeable difference between the early legal challenges to affirmative action and the challenges more recently involving TJ and involving Harvard, et cetera, is that the earlier plaintiffs were white and the more recent plaintiffs are all Asian American. Is this a change of strategy more generally, or is this just reflective of general changes in demographics, or maybe a bit of both? What's the difference in these cases?
Well, for us, I think, in TJ specifically, actually, the plan is designed to increase the percentage of white students who will enroll at TJ, because Fairfax County is 60% white and the school is only about 20% white. So white students are being deemed underrepresented at TJ. But I think in some cases it's strategy, but in a lot of cases it's simply because Asian Americans are the only race who are being discriminated against.
Well, I'm the hedgehog in this group, so I know one big truth, and the one big truth that motivates, I think, me and all of my friends and colleagues involved in this organization is that your race and your ethnicity should not be used to help you or harm you in your chances of admissions to a college. I say that over and over and over again, and it resonates with America. So But in terms of the legal strategy behind all of this, when it was decided that students for fair admissions would now test the constitutionality of race and ethnicity and revisit Grutter, we tried to sue 3 schools. We tried to sue Harvard, which we did. Same day we did that, we sued the University of North Carolina. And we also tried to find a group of students willing to sue the University of Wisconsin. That was unsuccessful. So our plaintiffs in UNC are white and Asian. Our plaintiffs in Harvard are Asian. No one knows, or at least no one knew back in November of 2014, which case would make it up to the Supreme Court faster. As it turns out, it was the Harvard case. So it was kind of, it wasn't necessarily pushing the idea that, Asians now need to be in the kind of the legal mix in all this.
So another question, so conservatives were obviously very excited by the University of Michigan cases, and then later by the 2 Fisher cases, all of which reached the Supreme Court, but then were later on disappointed by the way the court ruled in those cases. Is the Supreme Court different this time, or is there anything different about these cases that can give people a bit more optimism?
Well, I hope so. When we worked on the Michigan cases, the swing vote was O'Connor. And in retrospect, she was never going to say that the diversity rationale had to go. In the Fisher cases, it was Kennedy, if I remember correctly. And he was very much a split the baby kind of guy. So the diversity rationale was not going to be discarded there. Now Kavanaugh is probably the swing vote. If it was Roberts, I'd worry. Roberts has been good on race, but he's also very politically correct these days. I guess you'd have to ask Justice Kavanaugh, but my point is that the center has shifted a little bit to the right. So there is a hope that this time they'll be ready to discard the diversity rationale, but then again, they may, these cases could lose in the Supreme Court, or they could win on narrow tailoring grounds with the diversity rationale surviving.
And so if Harvard does lose at the Supreme Court, is the court likely to overturn the diversity rationale or just rule on narrow tailoring grounds?
Well, I don't know. Anybody else's thoughts?
I don't know. One is we go from 15 milligrams of Ambien to 10 milligrams of Ambien to 5 milligrams of Ambien. So right now I'm approaching 15 milligrams. If they grant cert, then I'm down to 10, and it's unknowable. It's a great question. It's just completely unknowable.
It's usually pretty tough to predict what the court will do in any case, much less this one. So in 2003 in Grutter, the court said race-based admissions should sunset in 25 years. Do you think the court will mention or even rely on that when they hear the new cases?
I don't know. It seems that the arguments that Harvard made in their briefs characterized that 25 years as aspirational, not really a bright line. So I don't know how the court would, if the court sees that as a bright line or aspirational, it's unclear to me. We're getting pretty close to that 25 years, but again, these are unknowables right now.
Well,
I'll chime in here on this.
If I was the court, I would rely on that, because then you can say, hey, we're not overturning Grutter. O'Connor said 25 years and we're sticking to that. So you've got another 7 years, and wind it down during those 7 years. So, that might be a good sort of compromise for the court to take. And, it would be hard to categorize that as radical because O'Connor, who was quite moderate, said 25 years.
I think the thing that concerns me, and I'm not going to opine on the on whether that 25 years statement is binding or anything, but is that you've seen in the last 5 years that race-based admissions plans, at the K through 12 level, that have exploded, and if anything, the interest in race-based admissions has gone up in the last 5 years. So I wonder if that is a direct result of people worrying that there's a sunset, or if it's just related to critical race theory or any number of things. But I have noticed that it's not like we're all coming to an agreement that we no longer need these policies. People are pushing them more than ever now.
No, that's a good point. I mean, the court is, in some sense, even though it's a more conservative court, it now sits in the middle of society that's almost obsessed with racial preferences since the George Floyd incident, where, the establishment, be it schools or corporations, just go around bragging about, basically all the special benefits for Black people, if not other minorities. But, getting back to the 25-year thing, it's interesting. Right after those decisions, when I was doing a lot of panels like this, the supporters of race-based admissions typically said, I don't think it's binding, but yeah, of course, 25 years is reasonable. The whole point of affirmative action was always just to sort of level the playing field. They really had no objection to it. And then, a few years later, they started to question a little more. And now I would say the opponents think the 25-year limit is nonsense because, not surprisingly, the underlying problem hasn't gone away. The underlying problem is that when minorities apply to college, they tend to have somewhat lower grades and test scores, such that if you apply the same standards, there'll be less Black kids at the college and somewhat less Hispanic kids. And that's the underlying problem, and we've done nothing to remedy that. All we do with racial preferences is cover it up. So not surprisingly, nothing has gotten better in the last 18 years since O'Connor said 25-year sunset.
We have kind of a relevant question from the audience. Kurt, you mentioned exams. The question for all of you, just like purely exam-based admissions discriminate against any race?
Well, that's an argument that certainly I've heard the other side make in debates, that the standardized tests themselves are discriminatory. It's not an argument they typically make in these cases, although I think there have been, if I remember correctly, cases directly challenging the SAT, might have been against the College Board. But, there's been the constant message outside the courts, at least, that these exams are discriminatory. And I think that's why schools are emphasizing them less now, because they're, in a sense, I think of it as shooting the messenger. The messenger is just telling you the truth, which is minority kids are, graduating high school with somewhat lower credentials than white and Asian kids. And, one way to deal with that is shoot the messenger, get rid of the tests that show that discrepancy.
I have seen that argument made in actual litigation concerning K through 12 exams. I've never seen it actually succeed, but that's definitely been in the background of our New York case. I think there's still a OCR investigation pending into whether the SHSAT or the SHSAT in New York City is racially discriminatory. But the test has been validated, meaning that according to the professionals in that field, it predicts what it's supposed to predict. So that's, and the SAT has been shown to be predictive of college success far more than grades or any other factors. So, the tests work. And I think there's been even more, there's been more literature coming out recently about how holistic admissions is actually more discriminatory against low-income students than test-based admissions because of the availability of extracurriculars at elite prep schools, and how high-income students have more time to pursue things that would round out their application.
Which is pretty ironic because the movement to rely on standardized tests for admissions came about, if I remember, about the middle of the last century, when there was a perception that most of the kids going to the top schools came from these prep schools. And one reason that they did was because there was no great measure of potential. And so what do? You do the safe bet and you take the kids from the prep schools where you have a long history of knowing that they'll usually succeed in college. And so standardized tests were supposed to level the playing field. And it's ironic that now, we're going in the opposite direction. And because people don't like the, as I said, don't like the messenger, we're going to go back to a more holistic process, which, may be intended as a cover for racial preferences, but at the end of the day, allow all kinds of individual biases to, creep back in, the very ones that, we were trying to get rid of 75 years ago when standardized tests came in.
Well, back in the 1920s, and this is well documented, Alan Dershowitz and others have written extensively about Harvard and its Jewish problem. And we document in our complaint and in our briefing, and the amicus briefs that came in support of our cert petition went into great detail on this. And the early and mid 1920s, Harvard had an admissions test. You wanted to go to Harvard, you just passed the test. Well, guess what? By around 1925, 26, 27, about a quarter of Harvard's incoming freshmen were Jewish. And this was unacceptable to the kind of to the Yankee blue bloods that had sent kids to Harvard. And what did Harvard do? This was the birth of holistic admissions. Harvard then decided that there were just too many Jews here. They had personalities and characteristics that weren't really that of Harvard men. So we're going to add various factors, very holistic admissions factors to Harvard's admissions policies. And within a year of that change in policy, the number of Jews being admitted to Harvard plummeted. So we have an interesting dynamic here with tests and then holistic admissions, and now an assault again on tests. So we'll see how this plays out.
And if you look at the language that they used in the 20s and the 30s, it sounded a lot like the diversity language that we hear today, which was, hey, it's not that we don't like Jewish people, it's just we want a representative student body. Was the same, now there's too many white and Asian students, then it was too many Jewish students. Who wrote a great article on this right after the Bakke decision, Alan Dershowitz, tore it apart, talking about how the diversity rationale was exactly what was used to keep Jews out of schools decades earlier. He later changed his mind, when political diversity became sort of the political code word. But the new, more conservative Alan Dershowitz may think what he originally wrote in the late 70s.
So we have a couple of questions I'm going to try to get to quickly here before 3 o'clock. So how worried are the litigants that one of the originalist justices might uphold affirmative action because of the racial preference policies during Reconstruction?
Wow. I'm going to take a pass on that. I'm going to let a couple of the real lawyers speculate on that. That's clearly out of my my realm of speculation. Go ahead, John.
the other side sometimes, and I don't even remember at this point if, to what extent this was in debates and to what extent it was in their briefs, so that was somewhat in their briefs. Their argument is that equal protection was not intended to be completely symmetrical, that it was, intended to protect Black people. And they point to things like the Freedmen's Bureau after the Civil War. And they say, this idea that equal protection, we have to have the same standard for discrimination against whites that we do discrimination against Blacks, just doesn't make any sense historically. I guess, unfortunately for them, the Supreme Court has never adopted that. The Supreme Court officially says that it's a completely symmetric equal protection standard, and also under Title VI. And they would say we're applying the same strict scrutiny to, Ed's case and to Chris's case that we would to discrimination against Blacks and Hispanics. But of course, no one really believes it's the same standard. It may be they go through the ritual of using the same words, but of course, it's not really the same standard. So of course, the justices are already in effect taking into account, the effects of slavery in the Civil War. Even if, Ed and Chris win in the Supreme Court, the language that you're going to get from the conservative justices is not going to be how horrible, this is, which is what they would say about discrimination against Blacks and Hispanics. It will be, well, this has a noble intention. The time has come to, blah, blah, blah. So of course the justices are affected by the history of discrimination in this country.
Yeah, I agree. I would just add, I guess, as a matter of originalism, most originalists today subscribe to a regional public meaning. So the intents surrounding the 14th Amendment, really, I don't think would play into, say, how Justice Gorsuch or Justice Thomas, Justice Thomas is already on record supporting a colorblind constitution, but how Justice Gorsuch would view it. The Equal Protection Clause doesn't discriminate, doesn't give any distinction between races. It's a colorblind clause, as the elder Justice Harlan said in his dissent in Plessy, and that's been the argument that we've made for years, that we have a colorblind constitution and it should be enforced that way. I agree that that's not how it's always been enforced, and I think there's definitely a sort of underlying worry that it's certainly true that the justices don't consider racial preferences of today to be equal to segregation or Jim Crow or anything like that, and maybe as a moral matter they're not, but as a legal matter, any racial discrimination, our position is racial discrimination is racial discrimination.
So I have a question here related more to the likelihood of a cert grant. This is probably the last question we're going to be able to get to, so apologies if I didn't get to your questions. But this question says, the Supreme Court is in a society of supercharged race-based policy. Yes, but which way does that cut regarding deciding to hear SFFA case and later ruling? Might a heavily conservative court want to wait to allow racial tension to decrease, or might 4 justices vote to take the case but be concerned they can't get a 5th on the ruling?
Well, I think it's let me let someone else speak first.
Well, no, I'm going to sort of once again say these are good questions, and they're all unknowables. That could very well be the guts of the conservative justices right now. On the other hand, it may not be. It's hard to say. Remember, Justice Roberts wrote the opinion in Shelby County, Alabama versus Holder. It was a very consequential opinion. He, to this day, is vilified for that. So I'm hopeful, without speculating, that yes, we are in a world in which race and ethnicity seems to be elevated within our arts, our culture, our corporations, our educational systems. But the justices seem to often step forward and take difficult cases, as they have with gay marriage and Bostock just last term. So I'm hopeful.
Although you just named two cases that one would make one hopeful about them taking the case, not about them ruling the right way, because of course political correctness won out in those cases. And I guess Kavanaugh is probably the biggest worry. I mean, he didn't need his vote for cert. I don't know, voted for cert, but he is, I guess you have to say, a little bit like Roberts, part of the establishment, worries about his press, and whether he would have the guts to get rid of the diversity rationale, I don't know. But it only took 4 to grant cert, and I'm going to assume that they thought there was a 5th vote, maybe not to overturn the diversity rationale, but at least to improve the situation, which wouldn't be that hard to do. Putting more teeth into narrow tailoring would be helpful. But look, cases come up when they come up. You can ask Ed why he brought the Harvard case when he did, but it probably was, had nothing to do with considering whether the court, years later would be in the right, political mood to do this. And it was the same with the Michigan cases. I remember after we, for the most part, lost those cases, I asked someone connected to the court, what could we have done differently? And this person said, O'Connor was never going to get rid of the diversity rationale. The only thing you could have done differently was not ask for cert. And that's probably true. The court was just not ready at that point to give a good ruling. And is the court ready to do it now, given, all the tumult in society? We just don't know. Chris, your thoughts?
You're on mute, Chris.
I try to stay away from political speculation about the court. I mean, I really don't know. I'm kind of a formalist, so I like to think that the court, wants to just follow the law. But I realize there are a lot of other considerations, and I can't even begin to guess as to what the court might think of here in deciding, to grant cert or how they're going to rule. I can only hope.
For the last 2 minutes here, I know Chris has a strict cutoff at 3 p.m. So we'll have to end things there. Do any of you have any very brief closing thoughts?
Thanks for having us. I appreciate the opportunity to visit with Chris and Kurt. Thanks for organizing this. Appreciate it.
And I just want to thank, Ed and Chris for keeping up this fight. I sort of left the fight for the most part to go to the Committee for Justice, which at the time at least focused on putting better judges on the court. So I think part of the reason I made that move was, I realized I started out, young and naive and thought it was all about making the best legal arguments. And then I realized, and that's probably true of most Supreme Court cases, but on these hot button issues, it really comes down to the judges and all the things they worry about, which is more than just the law. And that's when I realized most of the things that, at least this group would like to achieve depends on having the right people on the courts. But, you're talking to Chris and Ed, two people right on the front line. I mean, Ed really has, kept this movement alive. After Ratzenberger, a lot of people, including people at the Center for Individual Rights, where I was, were just disgusted with it. And Ed never lost his energy. And so I still has it today, as you can see. So I want to thank him. And Chris, PLF is doing great work on this now. You have several cases going. We'll see if they reach the Supreme Court or not, but certainly, Chris and PLF are leading players in this fight. So I'm glad to see, 18 years after, I thought everyone had sort of given up hope that the fight is very much alive and may bear, great fruit in the next year.
Yeah, I realized I neglected to mention that, in the TJ case that we actually we defeated their motion to dismiss just recently. So in that case, that was the first time we ever saw a judge agree with sort of the argument that under Arlington Heights, a race neutral admissions program can be discriminatory simply because it seeks to employ racial balancing. So there's some hope there that is a cert-worthy issue coming up even outside of the diversity rationale. So I realized in talking about the case, I never said that we had a pretty big win, a preliminary win in the district court, but a win recently. And yeah, thanks for having me, and it was a great discussion.
Thank
Hi,
you.
guys.
Sorry. Yeah. Thank you all for attending. That's all we have for today. I'd like to thank the panelists and all the attendees for a really great panel. Thank you.
Thank you.